Oh, you're back. Well, it's time for the third installment of our introduction to administrative law. Now, we've already talked about the where question. In an institutional sense, where are these regulators? In what institutional contexts do they work? And we've also talked about the who question. Who are the regulators? What is their typical career path, and what does that tell us about the tendencies and incentives of the people who are doing the regulating? Now we're going to turn to the what question. What is it that agencies do? And the answer to that question has a few subparts. Now, it's often said that regulatory agencies combine within one entity all three of the major separation of powers functions of government. So agencies act like legislatures sometimes, and they draft rules, make rules. They act like executives sometimes, and they gather information like the police, or they prosecute violations of the rules like prosecutors. And sometimes they act like judges. They at least initially determine disputes between the regulated parties and the enforcement wing of the agency. So within, under one roof, we have all three of the major branches of government at work. This conundrum has really just exploded the minds of constitutional lawyers for over a century now, but that's the reality that we have, is all of these functions combined within a single entity. So as we answer for this presentation, what do agencies do? We're going to focus on the legislative part of that answer, and that is agencies make rules, just like legislatures, or at least something like legislatures. You could call them quasi-legislatures. Now, an agency can't just go out and start writing rules about whatever strikes its fancy. Agencies only exist when Congress, or the state legislature, create and fund them. And they can only address public problems when Congress delegates that authority to them. So they have to stay within the bounds that the legislature sets in the statute. And that means typically the Congress is passing an initial statute. It both resolves some of the big answers to public problems, and it creates an agency and says to the agency, you go out and finish what we've begun. We've given you the broad outlines, now you fill in the details and you enforce this. And then later on, another statute may come along and add to the work list of that agency, and it'll say, all right, EPA, we gave you the Clean Air Act to work on. Now we're also going to ask that you regulate toxic substances, and so add that to your to-do list. So at any rate, the agencies, EPA or HHS or any of the other agencies, can only exercise the rulemaking authority that is delegated to them by Congress. Now, the delegation that goes from the legislature to the agency, the marching orders from the boss, really, they can often be quite broad. Congress will typically write laws in very broad strokes. There will be some scattered spots of excruciating detail, and so you can get statutes that are thousands of pages long. Nevertheless, there are bound to be, in these, especially in major legislation, statements of broad principle, leaving some very difficult detailed choices to somebody else, that somebody else being the administrative agency. One example is, of course, the Affordable Care Act. It tells the Secretary of Health and Human Services, a pre-existing agency, but it was given the job of fleshing out this major new set of public requirements. It tells the Secretary of HHS to work with the states to set up exchanges for health insurance. These are online markets that will allow consumers to comparison shop for health insurance. But there are a gazillion details about the exchanges, what they're going to look like, who qualifies, what are the minimum benefits that must go into an insurance contract, what limits, if any, will there be on the maximum and the minimum prices that can be charged. Some of these questions are addressed at least partially in the legislation, but a lot of them, really most of them, are left to HHS to work out the details, given the general marching orders from Congress. And so the agency sets out to fill in those details. Sometimes the agency, years later, will take a very small, sort of vague grant of authority and use that to address some major new problem. The Food and Drug Administration did that for some years with tobacco. The EPA has been working on greenhouse gases on the basis of somewhat generic language. So the very broad delegations become even more important in the out years as new problems crop up that the original Congress did not specifically envision. Now there is a statute, the Administrative Procedure Act of 1946, that tells all of the federal agencies how they're supposed to go about making these rules. They don't just go off to their office and type something up and hit send and then it's a law. They have to go through a process, and that process is designed to consult with people and to let people know what's going on. This process has a name. It's called the Notice and Comment Rulemaking process. It is where the action is with administrative agencies. This is where the stakes are highest. This is where real dollars are at stake, where all the affected parties invest the most effort, whether it be the targets of the regulation, the people who are going to have to change their conduct in light of what the agency tells them to do, or the regulatory beneficiaries, that is, the people who are going to benefit from the targets changing their behavior. In fact, you could often look at the administrative agency as kind of a mediator standing in between the regulatory targets and the regulatory beneficiaries. But as part of doing that, this 553 notice and comment rulemaking requires the agency to make the rounds and to get the kind of information and consultation that will lead, hopefully, to more fully informed and well-grounded rules. So exactly how does this process go? Well, you have the language of the statute in front of you here. And it's called Notice and Comment Rulemaking because those are the first two steps of the process. So when an agency thinks it's time for us to flesh out the details of something that Congress wants to happen, first thing you do is send out a Notice of Proposed Rulemaking. Administrative lawyers love acronyms, and so this is known as a NOPR, an N-O-P-R, Notice of Proposed Rulemaking. Notice that it doesn't have to actually contain the terms of the proposed rule. The agency might just put out there the general subject that it's going to regulate, but it's most common for an agency to at least put a preliminary version of its rule out there in the world. What we mean by out there in the world is in the Federal Register, which is both a hard copy and electronic newsletter of the administrative state for the federal government. And people in regulated industries follow this Federal Register with great, with bated breath, waiting for what's going to come out in today's edition. So we've talked about the first step in the notice and comment rulemaking process, and that is notice. The second step is, of course, comment. That is, the agency, once it's put its rule out there, or at least the substance of the topic out there, it's supposed to wait and receive comments. Comments from whom? Really from anybody. They're supposed to receive comments from anybody. Now, that being said, typically who they really hear from will be parties who are interested, who will be affected, very often financially. Typically, trade associations, groups of affected private firms will get together. They'll probably hire a law firm that specializes in regulatory work, and that law firm will put together a letter explaining to the agency why the rule is a bad idea and too expensive, or maybe some regulatory beneficiary groups, say the Sierra Club or the Consumers Union or something like that, will put together a letter explaining why you're not going nearly far enough and you've got to limit these rascals to do less harm in the real marketplace. So they get letters from all sides. They could be handwritten letters. They can take any form. There are now electronic submission methods. Some agencies are experimenting with e-rulemaking, electronic rulemaking, that push the notice of rulemaking out there to the public to encourage more feedback from the public. One thing that the agency gets with these comments coming in is extra information. The agency very often can't anticipate how its rules are going to actually play out on the ground, and the firms that are most affected can give a real detailed picture of that. Now, sometimes you have to take it with a grain of salt, but it is highly valuable information to learn that, for instance, you're asking us to do it one way that's very expensive. You could change the way you ask us to do it. You could get just as much benefit, but it would cost, way less. The agency listens to things like that and very often will adjust its rule accordingly. And this brings us to the third step in this process. After the initial notice goes out and then the agency receives all the comments, it's supposed to somehow react to those comments. And so as the statute puts it here, after consideration of the relevant matter presented, an agency shall incorporate in the rules adopted a concise general statement of their basis and purpose. Back to our acronym habit, administrative lawyers call this the CGSBP, the Concise General Statement of Basis and Purpose. This not only describes the precise terms of the new rule, it also explains why they're there, something that legislatures don't have to do. Legislatures just stick the statute out there, but the agency has to put its rule out there along with an explanation. And that explanation has to respond to the major comments that came in during the comment period. Maybe not every single little comment, but all the important major comments that come in, the agency has to respond to them in some substantive way in its CGSBP. And you just publish the whole package. For some relatively minor rules that don't have a big dollar impact, that's the end of the line. The notice, the comment, and then the agency's response to those comments in its concise general statement of basis and purpose, published along with the final rule. But for some major rules, the ones with big dollars attached to them, that's not the end of the line. At that point, the agency has to send its rule to the White House Office of Management and Budget and the subunit there, OIRA, the Office of Information and Regulatory Affairs. And we have there regulation specialists, people who do a cost-benefit analysis of the rule, and they try to decide, what dollar amount can we place somehow on the health benefits and the other, the lives saved, the injuries prevented and so forth from this rule, and what's our best estimate about how much this rule will cost, the private parties to comply with it. And you weigh those up and you say, are the regulatory benefits greater than the regulatory costs? There's a lot of imprecision involved in this, but the original agency is supposed to go through this cost-benefit analysis, and then the White House review team at OIRA also goes through a cost-benefit analysis asking, is the rule worthwhile? If OIRA decides it is, then they send it back to the agency with a thumbs up and they say, fine, go with it, that's great. But if they think maybe the costs of this rule are too high given the likely benefits, they can send it back to the agency. OIRA doesn't have the power to kill the rule outright, but they can force the agency to go through the process again and do a new cost-benefit analysis and think about it. So there's some back and forth between the White House and the agency that actually has the statutory authority on the question as to whether to go forward with the given rule. For some complicated rules, the agency will also supplement the notice and comment rulemaking process with a negotiation process. They'll invite to a negotiating session all the important stakeholders as the agency sees it, both some representatives of the regulatory targets and representatives of the important regulatory beneficiaries. And they'll sit down at a negotiating table and try to hammer out some kind of possible rule that that satisfies the requirements of the statute, but also does it in a way that, that the regulatory targets can live with, in a way that's as cheap as possible. And if the parties come up with that agreement, then the agency would run it through its normal notice and comment rulemaking process to get comments from other people who weren't invited to the table. And if at the end of that, the agency is satisfied that it's the right move, carrying out its statutory obligations, then it'll enact that as the final rule. Some agencies like this negotiation process because it tends to insulate the rule from challenges by disgruntled parties. If they've signed off on it from the beginning, they're less likely to challenge it in court later on. Now, not all of the general rules that agencies write go through this informal rulemaking process of 553 notice and comment. Some rules go through a more formal process where the agency actually sets a date, holds a hearing, and parties come in and testify, and the agency then responds on the record. It looks something like a trial. This method of what we call formal rulemaking has disappeared for now from the scene in American administrative law. It was quite expensive. There are ways maybe you could cut the costs, but at least at the moment, formal rulemaking is not something that you normally would run into. It's quite a rarity. On the other hand, what we call Sub553 rules, that is, rules that don't go through the formal process and don't even go through the informal notice and comment process of 553, something less than that, under that, Sub553. Lots of those rules happen, and in fact a growing portion of the agency's output happens through this very informal process where the agency just sticks its rule out there. You have to publish it, it's got to be public, but they don't go through the whole solicitation of views that is built into the notice and comment process. And you notice from the statute here, you have in front of you the language from section 553 that lists the requirements or the exceptions to the 553 process. And so notice it does not apply to interpretive rules, those times when the agency just says, this is what we think the statute requires, and we're going to try to enforce this against you whenever these conditions are present. So it's just the agency's reading of an existing statute or some older administrative rule. Or a statement of policy where the agency says, we don't have resources to go after everybody who we believe has violated any one of our rules. So these are our priorities. We're going to go after people who get above this level of, discharge into rivers for water pollution or whatever the cutoff point is. They state that these are our enforcement priorities, these are our policies, but if you do something contrary to this, it's a separate question whether that's really illegal or not. We're not trying to create binding rules here. We're just giving you a little notice about how we're going to enforce things. Or if it's purely a rule of procedure, just, you have to submit your arguments, in PDF format or within 10 days of the initial notice or whatever it is. Procedural rules don't have to go through the whole notice and comment process. These different exceptions have grown over time. Agencies have been quite aggressive about this, so we get a lot of rulemaking that turns out to just be declarations by the agency. Some of these are temporary, some of them take hold on a more permanent basis.